Hi, Andy Nelson. Today I want to talk specifically about trademark use on apparel. Now, this is something I know a lot about because I have represented a lot of apparel companies over the years. And I get asked questions about trademarks for apparel weekly, if not more than weekly. So I get asked this a lot. And here is a thing that happens a lot. A lot of folks come up with an idea for a piece of graphic art or a slogan or a saying or whatever you call it, and they say, "Oh, I'm going to sell shirts with this, and I want it to be I want to protect it. I want it to be a trademark." Got to be careful with that, because what happens often is, and this typically happens when people do this on their own, they apply for trademarks for apparel, and what you do when you go through the process is you submit a specimen of your trademark, how it's used in commerce, how consumers see it. And what folks often do is they take a shirt and they'll submit the JPEG of their shirt, which has their graphic or their slogan or whatever, all across the shirt. And what happens? The examiner comes back and rejects it and says, "No good. This is not trademark use. This is likely to be perceived by a consumer as merely ornamental." Okay, what that means is the consumer is unlikely to view that decoration, that ornamentation, as a brand signifier, as a source identifier, and instead just see it as decoration like we all have on our clothing all the time. That's a big problem. So what you got to do to avoid that sort of refusal is this. You got to use that, even if what you think of is going to be decorative, ornamental, you want to, in addition to that, use it or affix your trademark in a kind of a conventional, classic way that we experience trademarks on clothing. So here are a couple examples, and I'm actually wearing one. So first, right here, upper left-hand corner, or it could be right, doesn't matter, but the upper chest smaller, that tends to be kind of a classic trademark use. That's an option, and that works with polo shirts typically, maybe t-shirts, but maybe other sorts of outfits. That's one way. The most classic way is to use it right here. Neck label, right? So you put the mark in the neck label. That is where we all would recognize seeing it. Sometimes it's going to be, this is a Nike shirt with my own law firm on here. But sometimes it's going to be Hanes or something like that with your decoration here. That's probably not going to work. You want to have your own here. And a lot of companies will print those for you. They'll print your neck labels custom made. They won't be actually neck tags anymore. They're typically just printed in. That's another way. Another conventional way, which is a little more modern, but it's acceptable, is right here. Look at that. Nike swoosh on the sleeve. So on the sleeve too, that's how consumers experience trademarks, and they recognize those kinds of placements as a trademark or a source signifier. Lay here, sleeve, neck label, upper left chest, sometimes now back of the neck, you see that often nowadays, or a hang tag. If you have a hang tag with the mark on it, again, consumers don't see that as ornamentation. They know that's a classic trademark use. Or probably a little more rare now, but let's say you deliver a shirt and it happens to be like in a plastic bag or some kind of tissue wrap or something like that. That might work as well if you have the marks on that, because it's not ornamenting the product, right? It's really ornamenting the packaging around the product. So those are more the classic ways. I get it. If you're gonna, put out clothing, apparel, or not just shirts, but hats, shorts, for example. You have something all across the booty, or just all across the hat. Put it inside too on the tag, or on the back of the hat in a small spot. On the shorts, I suppose maybe tiny, on the front leg, something like that, or the tag, again, the inside label. Those are classic trademark uses that are likely to get by a trademark examiner at some point. Or even if you don't go through the trademark registration process, you just use use-based rights, not registered rights. Again, if you have to enforce them, you may run into a couple of hiccups if your mark use isn't one of those classic senses, because somebody on the other side might say, you don't really have trademark rights. You haven't built up trademark rights. You've just been using your claimed mark ornamentally, not as a trademark. So that could be trouble. Anyway, that's kind of the lesson for today. Again, for apparel, those who trade in apparel or other clothing, those sorts of goods. If you have any questions about this video, drop a comment, shoot me a note, and if someone would benefit from the contents of this video, please feel free to share it. Until the next one, have a good one.